Welcome, everyone. My name is Jennifer Hill, and I'm the Director of the Centre for Commercial Law and Regulatory Studies, or CLARS, at Monash Law School, and I'm very privileged to welcome you to this CLARS Mallesons, King and Wood Mallesons seminar this evening, and we're incredibly grateful to KWM for hosting us this evening. So before we get underway, I'd like to acknowledge the traditional custodians of the land that we're on today, the Wadawurrung people of the Kulin Nation, and I pay my respects to the elders past, present and emerging, and also to any First Nation peoples who are joining this evening, either in person or online. And I'm told by Tamara Wilkinson, we do have about 120 people online, so we have many people, more than are in this room. So my partner, Ron, who's a financial economist, and many of you know, he's fond of reminding me that timing is everything, and the timing of this evening's seminar could not have been more perfect or fortuitous after the somewhat controversial Senate Economics Reference Committee's recent report involving ASIC. And so tonight's seminar is on the topic evaluating ASIC and private enforcement, directors' duties and disclosure laws, which is always a fascinating topic, but made even more so as a result of that report. And we're very fortunate this evening to have my dear friend and colleague, Dr Jenifer Varzaly, and the Honourable Justice Ashley Black as speakers. So let me just tell you very briefly about Jenifer and Justice Black. Jenifer is Assistant Professor of Commercial and Corporate Law at Durham University Law School. She's currently based in Australia for a while. She's a Research Associate at the Centre for Business Research at the University of Cambridge, and she holds degrees from University of Adelaide, Cambridge and Oxford. She's been a visiting academic to Columbia University and Stanford, and she works in the fields of comparative corporate law and governance and law and finance. And we're just so glad we've got her down to Melbourne and able to have her as a speaker this evening. Justice Black virtually needs no introduction to most of the people in this room. He became a judge at the Supreme Court of New South Wales in 2011, and before that he was a partner in dispute resolution at Mallesons, Stephen Jakes, as it then was. And so he primarily practiced commercial litigation and financial services regulation. And our students at Monash at the moment are having a treat because he's teaching them financial services regulation as we speak. And you've probably been teaching them all day today. Yes, he's got a lot of stamina. So he holds positions as an adjunct professor at the University of Sydney Law School and a visiting fellow in the Faculty of Law at the University of New South Wales. And I think everyone in this room would be aware of what a prolific scholar he is, in addition to his judicial work. Before I pass over to Jenifer, who's going to speak for about 30 minutes, and Justice Black for about 10-15 minutes, or however long he feels like, let me just mention to the people who are online, we would love you to ask questions. So if you do have questions as the seminar is going along, please put your questions in the Q&A box, and please identify yourself, where you're from. And at the end, we will hopefully have time for your questions as well as questions in the room. So with that, Jenifer, over to you.
Thank you very much, Jennifer. And thank you so much for having me this evening. In particular, thank you to Monash Law's CLARS and obviously to King and Wood Mallesons for organizing such a wonderful event. And I'm very happy, as mentioned, to be here as a speaker. So I think in beginning this evening's talk, I don't have too much time, only 30 minutes, and I have a whole lot of data covering, over a 20-year period. So I think that I would mention that my research is still in its preliminary phases. So, I'm not going to have the complete data sets to go through, but I certainly get a sense of what enforcement looks like at this point in time in Australia. And as I mentioned, over the past 20 or so years. And I think also in looking at that, I look at directors' duties and disclosure laws, but not across all different types of actions. It is a little bit limited in that I'm looking typically at final judgments, or with the disclosure law data set, I look at what is currently in court. So what is been filed and what is being heard in terms of the class actions. So just with that in mind, I'll begin. So basically, I think I would say the unique selling point to this research is that I take a dual modality approach to examining both the functionality within Australia and the empirical incidence of not only public enforcement, but also private enforcement of directors' duties and mandatory disclosure laws in Australia. So I think the first thing that this allows me to do, which hasn't been done before in the context of Australian research, is to provide a comprehensive picture of the enforcement landscape in both of these areas. So I have two, as I mentioned, new hand-collected data sets involving these directors' duties and disclosure law breaches for further examination. And I think the second thing that this then allows me to do is look for some of the potential reasons we see these types of actions. So when I present this around the world, usually not with an Australian audience, a lot of the feedback I get is to say, well, why do we see this in Australia? Why is Australia so unique in terms of the types of actions we observe, or the incidence of private and public and the interaction between them? So I don't think I'll get to go into this just in the time frame this evening too much, but I have a theoretical basis or argument that I make in terms of why these patterns may exist. To briefly touch on them just as I begin this talk, one is the shareholder dispersion theory, which is to say that depending on how dispersed the company shareholder basis is, we might expect to see different types of enforcement predominating. The second thing that I look at is the institutional investor holdings in this space that gives us a sense of the shareholder dispersion, as well as an assessment of public regulator resources. I also look at this over a 20-year period. And then I examine, as a last point, which is very relevant to the report that has just been released this month in Australia on ASIC's effectiveness, I look at whether, in my view, the observed enforcement patterns are effective. And so I think this certainly touches on the same thing. And I do so by reference to a specific set of evaluatory criteria, being whether the actions compensate, deter, or signal. And by signal, I look at this almost as a supplementary form of disclosure. So that is to say, in Australia, if ASIC, for example, and public enforcement actions are publicized and we see them in the media or we see them in ASIC media releases, this is a valuable thing to observe because it allows the public, it allows our shareholders some insight into what is occurring in the enforcement space. So as I mentioned, those are the three criteria. Once again, I've done a lot of work on this and won't be able to cover it all in this short period of time. But I argue at the very least that we can determine whether we have an effective enforcement framework if we see compensation, deterrence, and signaling. And maybe we only see one of those, maybe we see none of them, but I look at this in relation to the data as well. So not just in terms of what I think there is, I look at it in relation to the cold hard data of the cases. So the constructed data sets that I have enable these criteria to be, as I mentioned, empirically examined, allowing for an innovative, I believe, assessment of the enforcement landscape. So to start with what I find as I go into it, overall, I think that the empirical analysis reinforces, certainly in Australia, the signaling function of enforcement. And it shows in my data sets, once again, that there is a reasonable degree of deterrence achieved in some instances. Those instances are where directors themselves are targeted. So that is to say, not only where we see corporations as defendants. So where we're actually targeting some directors in the actions, it can be in addition to the corporation, but it cannot be. We see very little deterrence in my assessment or in my argument where there are corporate defendants without any director defendants being named. However, we then see that the compensation rationale is not met, and this is in the disclosure law actions, nor is it met in the publicly listed company subset of my director's duty data set. So I think overall, if you were to try and put it into more subjective terms, I argue that we have a moderately effective enforcement framework, certainly with scope for improvement across both modalities of enforcement. And I think, some people might think, and certainly the report takes a more critical line than myself that was just tabled in Australia. I look at this as it shows us where we can improve. I don't think this tells us that Australia is doing a terrible job. And in fact, when I have been overseas, looking at, I think, a very top-down view or a very, international view of Australia, generally speaking, there are positive comments made about the role of ASIC and the uniqueness of what we do in Australia. And it's more when we go down into the depths or the details of this data that I think it really shows us how we can improve and what we can improve on. So I think going back to my central argument, what we really need to do here, and indeed this report does not do it, that we've just seen come out, is that if we want to really understand the effectiveness of this enforcement framework, we cannot confine it to a single modality assessment. And that is what we do now in Australia. So that is to say, if you look at most of these reports that have been written in Australia, and you look at the commissions that have come out, and I can go into, I think I've printed some of this out for us to go through in some detail here. What we see is that almost all of these policy discussions focus either on private enforcement or they focus on public enforcement, and they do not look at the interaction between both types of these enforcement modalities, which I think is extremely important for us to do if we want to have really a good understanding of the system as a whole. So, for example, if we look at the report, which I believe came out in 2014, which was the, Australian Senate launched in June 2013, the large-scale government inquiry into the performance of ASIC. I just go back to this just to give you some examples, referring this once again to the Senate Economics References Committee. This produced what was described as one of the most significant parliamentary reports to be delivered on the performance of major regulators. So this was 553 pages. Within this, only 2 paragraphs engage in the interaction between private and public enforcement within the securities law context. So here, it was just aptly noted that, class actions may serve as an alternative means of access to justice for investors where ASIC has not taken an action. But no enforcement data, no qualitative analysis is provided to support this statement. So we only see, one reference made to Justice Finkelstein's comments on the central class action, referring to the U.S. system of securities class action enforcement as follows. This is a paragraph. It is often said that these actions promote investor confidence in the integrity of the securities market. They enable our investors to recover past losses caused by the wrongful conduct of companies and deter future securities laws violations. And according to, they refer to the US Supreme Court, they provide a most effective weapon in enforcement. So this is all that, we hear. There's no analysis of, whether these actions are in fact contributing to our aims of recovering compensation or achieving deterrence. The bigger issue, I think, from my perspective, is that we actually need to know what is the interaction here? How are we seeing whether these aims are met by both types of enforcement so that we can make an adequately informed policy judgment? And I think, you see similar things coming out of other reports. So you look at the reports subsequent to this, similarly, there are a few paragraphs, subsequent to this, there was a Royal Commission into the misconduct, obviously, in the banking, superannuation, and financial services industry in 2017. The final report published in 2019. Here we see that there is, modes of formal public enforcement are certainly analyzed in detail from an enforcement aims and outcomes perspective, but there is once again no mention of how private enforcement either contributes to or indeed may detract from these aims. So we see that, certainly adequate deterrence can be achieved by a combination of enforcement modalities or a combination of remedies where there are overlapping actions, as certainly there sometimes are. But we just don't see the data on this point. And then briefly, I'll go to our latest report that has just come out. So this was 232 pages, came out this month, as you are all, I'm sure, aware. There are once again only 2 mentions of private enforcement, with both the committee itself and here the AICD in their submission taking a fairly negative view, I believe, on the merits of private enforcement, without once again any data or further analysis for us to really understand, what, why we are having this view, or what supports or detracts from that. So in looking at my data in its preliminary form, I'll just relate some of the things I find from taking a dual modality approach. So what we see in terms of case frequency over some of the completed data set period, it'll give you some idea of numbers. There were in the first part of my data set 1.6 directors' duty cases per year. The number of publicly listed companies represented in the data set, which was 13% of the cases, far exceeded the proportionate representation of listed companies compared with total registered companies numbers, which is less than 1%. And here, what this led us to find was that the research indicates a 0.08% probability that a publicly listed company will have one of its directors named a defendant. So within this figure can be contrasted to, just out of interest, the comparable probability in the UK, which John Armour has done research in this space. So Armour and et al. Report as indistinguishable from 0, and then it appears to be more similar with the US, which was a surprise finding, I think, because a lot of, at least my international colleagues, say, oh, well, Australia has a very similar system to the UK. We expected to see similar figures come out of Australia to what we see in the UK, but actually we are closer to the US in this regard. The results further indicate a 0.04 probability that a publicly listed company will have one of its directors named a defendant in a filed case. This exceeds the private enforcement intensity found in the UK, which previous research indicates likewise is close to 0. And this similarly appears to be more akin to what we see in the US context. So in terms of what the enforcement looks like, so what we see in terms of enforcement modality and company type is that the director's duty case study results show that there is a statistically significant relationship between the modality of enforcement and company type. That is to say that public enforcement, perhaps unsurprisingly, is more likely to occur within publicly listed companies, and private enforcement is more commonly observed in private companies. Conversely, within the disclosure law side of things and the disclosure law data set cases, private enforcement, as many of you would be aware, predominates in publicly listed companies. So perhaps surprisingly, 100% of the cases within the data set are supported by commercial litigation funding agreements. And with respect to the settled cases, the net settlement amount is tiny compared with the investor losses that we see. Regarding the claims that were made in these cases, just briefly, the legal issues in publicly enforced directors' duty cases vary systematically from the privately enforced cases. So ASIC was more likely to enforce duty of care and insolvent trading cases, whereas private parties were more likely to pursue the self-dealing factual patterns. And the results also confirmed that insolvency is a trigger for litigation against directors, which once again is perhaps unsurprising, but the data shows that there is a high incidence of private enforcement actions which are initiated by companies themselves as opposed to shareholders. And interestingly, so I term this private direct actions. This mechanism comprised a significant proportion of the private enforcement actions within the initial data set. So in relation then finally to remedies, the compensation orders were made in 32 of the director's duty cases. There were 31 pecuniary penalty orders, 57 director disqualifications, and 6 criminal penalty orders. And then if we look at and contrast this, the director's duty set data set to the disclosure law actions, Within the parties targeted by the disclosure law actions, 21% of the class actions I looked at, and in 27% of the ASIC actions, directors or officers were actually named as defendants in the proceedings. Further, there was at least one type of parallel ASIC action in 33% of the private enforcement cases. And 62.5% of these parallel actions targeted directors or officers, which I think is a good thing. And lastly, where public enforcement is observed in the disclosure cases, the actions largely involve administrative sanctions as opposed to litigation. So a total of 22 actions were brought by ASIC in this preliminary dataset period, with only 8 litigated civil or criminal penalties, meaning that 64% of the actions were out of court. So the infringement notice was utilized more than the alternative types of enforcement, comprising 41% of the actions observed in this dataset. So interestingly, only 6 actions specifically targeted directors or officers. So that is to say 73% of all ASIC actions targeted the company as opposed to the directors. So this can be contrasted with the director's duty cases in which litigation is dominant and in relation to which infringement notices are obviously not available. So if I have time, I'll go briefly to the theory supporting my work or the arguments that I make. So one of the potential reasons for these observed patterns, I argue, is the shareholder dispersion theory, which I mentioned briefly. The substitution theory and the publicity theory are the 2 other theories I advance. So the substitution theory looks at the fact that perhaps when we see a high level of public enforcement, this may be substituting for a low level of private enforcement. And conversely, when we look at the disclosure law data set, we see that the substitution theory seems to work in the other way. So we see that private enforcement looks like it is substituting for the comparatively low level of public enforcement. And the publicity theory is also something that I advance, which says that perhaps what we see is that some of the decisions made, and this is once again what I get from the data set, and I'm sure you all have much more to add to this in person that work in this space, it looks like ASIC is targeting, some of the companies and individuals that will garner some publicity, will get, in the media, will, send a message to the investing public that there is some action being taken here. So this tries to really look at, the empirical plausibility of some of these theories in relation to the data. So I can go to some of the results here too. So when I looked at this shareholder dispersion theory, the empirical results regarding share ownership patterns are as follows. So this was something that there's just not that much information in Australia about the share ownership patterns. So I looked into this. So within the ASX 50, 97.8% of the ASX 50 groups of 20 largest shareholders are institutions. And this indicates really an increase in their dominance compared with previous research. And second, the highest degree of concentration within the ASX 50 is 74.99%. The lowest is 22.76%. Third, what we see is almost all 100% actually of the 3 largest shareholders in each of the ASX 50 companies are institutions, and 97% of these shareholders are nominees, which means it's really difficult for us to then find further information as to who owns these shares. But then you can look, I looked to substantial shareholder data. So what you see is that there were 93 substantial shareholders across the 50 companies. And then you see kind of the concentration of that ownership within the different levels of control. So what this ultimately shows in relation to the data is that the shareholder dispersion theory is consistent with the director's duty case study results. That is to say, greater shareholder dispersion exists, obviously, in publicly listed companies. And this may indeed result, at least in my argument, with increased coordination costs and difficulty of private individuals then trying to come together and launch private enforcement initiate private enforcement actions, which I think is one way we might look at that. Conversely, when we look at this data, this shareholder dispersion theory cannot explain the disclosure law results. So we need to look at alternative drivers here. So here I looked at the substitution theory in the disclosure law data set. So if we look at the fact that there has been a market increase in our commercial litigation funders and obviously institutional investors in this space, this, I argue, conceptually served to offset some of the effects of procedural barriers, adverse costs orders, and general coordination costs. So it may be that the increased level of private enforcement in the disclosure law space may have been substituting for the decreased incidence of public enforcement observed. As I mentioned, the public enforcement results show more the administrative actions being taken, not the actual litigation. So substitution theory, I think it's equally of relevance in the director's duty context, where the high level of public enforcement observed may have been indeed substituting for the low level of private enforcement we see in this space, which was obviously apparent from the results I went through earlier. So that is to say, barriers to private enforcement that we see, such as restrictive procedural rules, litigation expenses, shareholder coordination costs, and adverse costs orders, may help to explain the low level of private shareholder enforcement observed. Whereas ASIC, if you look at ASIC, ASIC is less subject to collective action problems and coordination costs, and indeed has sufficient resourcing to deal with the costs associated with litigation. So I think the empirical plausibility of the substitution theory is of particular significance, given that substitution effects are entirely overlooked in the existing single modality literature. So that is to say, when we don't, in our current research, look at the interaction between private enforcement and public enforcement, we cannot see if there are substitution effects. We cannot see if where there are gaps in public enforcement, private enforcement is filling the space, or equally where there is private enforcement and sometimes there's criticism of there being too much private enforcement, for example, in the disclosure law space. We don't then look at how public enforcement interacts with that as well. So even as I mentioned previously in the data, maybe when our private enforcement actions target companies, if our public enforcement actions target directors, we may see some value in having both types of enforcement in that space. I think then the third theory being the publicity theory, I think that's really able to then augment our understanding of the factors which may influence regulator case selection and action type. So this is to say, as I mentioned briefly, that this theory posits that ASIC may focus on high-profile breaches, initiating enforcement actions, perhaps to maximize publicity and therefore to influence the conduct of directors ex ante, particularly where large companies may be involved. And I think that you see this not only in Australia, but in regulator behavior across countries as well, when you see that obviously budgets are limited everywhere. No regulator in any country can enforce 100% of suspected breaches. So there has to be some strategy as to how you approach the suspected breaches and how you may achieve your regulatory aims with case selection and action type selection in this manner. So in terms of, trying to influence, as I mentioned, the conduct of directors ex ante with the large companies. So I think this theory seems consistent with the findings that I have, that 13% of the directors' duties cases involve publicly listed companies, compared with the fact that they amounted to, within my data set, less than 1%, or in Australia in general, less than 1% of total registered companies. So there is a higher incidence of enforcement, relatively speaking, in the publicly listed company subset of the data set. So this looks like, suggests that ASIC in particular does target its resources towards large companies. And this is, again, consistent with the disclosure law data set, which looks at or evinces, I think, a clear focus on the enforcement of disclosure law obligations by publicly listed companies in Australia, with these actions being publicized, again, by the regulator. I think this publicity theory is associated with the level of regulatory resourcing. So here, when I tried to look at regulatory resourcing, that is to say, as ASIC budgets and their budgets directed towards enforcement actions, a significant gap was encountered in the literature regarding these enforcement inputs. So to take the analysis further, I created a data set that covered basically a 20-year period and constructed this. So what I did, which didn't occur in the report that was just released, and I think really needs to occur, is that this looked at not only the amount in, gross terms that we see, what's in the budget, in 2001, in 2006, in 2013, in 2024. What I looked at is the enforcement inputs per firm regulated net of inflation. So I think that this is something that has not been done. You can't just take the ASIC budgets as they are and just say, oh, well, this year we see that it was, X number of $100 million. And then 5 years later, it was this much more. And you can see then, like, I think what we see is you can't just look at the gross terms of an increase. And when you take the inflation out of it, and when you look at it per company regulated, and this could be a whole other talk I don't have time to go into right now, you actually see that it is not so straightforward. So the budgets do not increase exponentially over time, as is intimated in the report that was just released. It actually is very stable over time. So if you take out inflation and you look at how many companies they're actually regulating or actually responsible for looking at enforcement actions within, we see that this is stable over time. And in fact, there was a drop in real terms in the resourcing. I believe, I don't have that data set on me right now, but I believe it was in the 2014 to 2019 period. So I think, not having that nuance, it doesn't allow us to really understand, what the regulator is capable of doing, or indeed whether, to just make comments to say, for example, that there's so much money and, why don't we see more results, it a little bit lacks the nuance that we perhaps need to take to this area. So I think previous research, I'm not sure how aware people are here, but the previous international research suggests that, Australia's commitment to public enforcement is quite good. So I think this, once again, it lacks a depth of analysis or lacks a detail. But what we see, as I mentioned, is that, I think our budgets or this commitment to public enforcement did increase. We see in the real data per firm regulated up to 2013, decreased during 2014 to 2018. And it allowed me to actually compare the budgets to the actions I saw as well within the data sets, which I think is interesting because you can't make a direct link between, it's not a causative, link, but you can look at correlations between how much money our regulator is spending on enforcement and what types of enforcement actions we indeed see. I think in respect then of this concept of enforcement effectiveness, I think using the framework that I argue, because I know I believe I have maybe 5 more minutes, 2 more minutes. Okay, perfect. We'll wrap it up. So what my findings indicate is that compensation, as I mentioned, does not occur for breaches of disclosure obligations or for breaches of directors' duties, particularly within the publicly listed company subset of the data set. So what we see, once again, delving into this a little bit, is that compensation, some degree of compensation, is typically delivered in respect of the particular breach that is the subject of enforcement proceeding. But such proceedings are so few and far between that what we see is that they likely account for such a tiny proportion of all breaches that the overall level of compensation generated by the system as a whole is likely to be insignificant. Moreover, in respect of loss coverage, the disclosure law actions where remedy or settlement data is available, and it's not always available, indicate that the net recovery amount is tiny. So similarly, the compensation rationale is not met in the publicly listed company subset of the director's duty data set, regardless of whether we look to public enforcement or private enforcement. There is just a conspicuous absence of compensation which is sought or ordered in these cases. In relation to deterrence, just very briefly, a deterrent impact is indeed likely where directors themselves are sued. So whether this is for breach of disclosure obligations or for breach of duty, and penalties imposed, importantly, are likely made out of pocket. So this is also what I look for in the data set if I can. can. So some remedies are more effective in this regard. So if you want to generate a deterrent impact, and I've written a lot on this, basically what you need to do is look to, for example, some remedies such as criminal penalties and disqualification can constitute a significant loss for directors. Yet, as with compensation, I think the paucity of actions that we see that order these things or that seek these remedies means that the risk of a penalty being ordered against the director is indeed very low. So this is compounded, I think, in the case of the disclosure law actions by the fact that the overwhelming majority of the limited number of actions that are brought, as I mentioned, are brought against the company as opposed to being brought against the directors. However, and on a positive note, is that the empirical results, however, support the argument that this system actually provides a very valuable signal, and not all other countries or regulatory systems do this. So because we in Australia do a reasonably good job of publicizing these actions, we do credibly convey information about director conduct. So this is particularly the case when the deployed enforcement modality is public, given the fact that ASIC tends to use point-in-time ASIC media releases, which allows for the public tracking of actions from their initial stages up until completion. And this is whether the action is litigated or indeed is initiated as a less serious form of enforcement, such as an infringement notice or an enforceable undertaking. So I think I'm probably out of time. So I'll just look at the fact that really what we see is the best thing I think that is being done thus far is that when we see the publicity of these actions, that what we then see is the observed enforcement serves to reduce information asymmetries, which exist between directors and the board, shareholders and third parties, and therefore can assist in decision making. So I think in sum, this data analysis provides reasonable fragments of evidence in support of this being a moderately effective enforcement framework, with notable room for improvement across both modalities of enforcement. So I think, what we see relating this back to all of these policy discussions, however, is that I think what we need to do is look across both modalities. So I think if you do that, then you get a sense of what each modality is achieving, where we're targeting directors. And indeed, sometimes we see when in my data sets, there may be a private enforcement action that targets the company, and then an ASIC enforcement action follows and targets directors. And in this report, for example, I think some of the nuance is lacking. One of the criticisms made is that the actions are too slow, they come too late. Depends on the context, all depends on the depth of the details. So if an action comes late, but it is filling a gap that a private enforcement action has missed, and it is then augmenting the deterrent impact of the enforcement action when you look at public and private together, I think that is a positive thing. So we see many examples within these data sets of how sometimes these actions work very well together, and indeed sometimes these actions cover the same ground where you'd say that doesn't make sense either. So that's a waste of regulatory resources. So the key takeaway from my research in a nutshell, I think, would be to say that, we are making decisions on misrepresentative information if we don't look across both modalities of enforcement, where both modalities are clearly enabled by the legislation. Our, ASIC in its document says that, private enforcement may serve a valuable role where we can't enforce everything. And so if we then get a complete picture of that enforcement landscape, then it allows us to understand the drivers, the points or room for improvement, and then to move forward, I think, in a very positive way, because as I mentioned, I think the international view of Australia and ASIC has been that we do a pretty good job. And so thank you very much for having me. Yeah, thank you.
I very much welcome the opportunity to comment on some of Dr. Varzaly's work, and also to take that as an opportunity to make several comments of an impressionistic character about enforcement more generally. I will keep myself rigorously to 15 minutes. I will have a more detailed paper which addresses some of the case law and the literature, which will be on the Supreme Court of New South Wales website in the next couple of days. First, I should note that Dr. Varzaly has written several interesting articles about enforcement, and plainly we've had a preview of work in progress today. Her first, or at least the first that I have seen in 2015, is a very interesting article relevant to her presentation today, dealing with directors' duties and drawing the distinction between public and private enforcement of directors' duties. And one thing she there recognises, which those who see things through the Australian perspective would not regard as unusual, but which is in fact very unusual, at least if you compare it, as Dr. Varzaly has noted, with, say, the United Kingdom, is the level of public enforcement in Australia, which is truly remarkable by the comparison with the level of activity in the United Kingdom. And as Dr. Varzaly also notes, more consistent with what would be seen in the United States. The second thing she notes is the lesser level of private activity, at least in respect of public companies. But one thing which is consistent with the substitution model to which she refers is, of course, there is a significant level of oppression and shareholder actions continuing with much less publicity in the courts in the several states in particular. Subsequently, Dr. Varzaly has written a second article in 2021 dealing with the effectiveness of disclosure law enforcement, and here again noting the existence of public, private, and sometimes both actions in respect of disclosure matters. Here she rightly points to the comparatively high level of public enforcement in Australia, although again picking up her substitution model, intuitively one might think that the explanation for the lesser level of ASIC court actions in this territory is the increase in class actions. And that in turn has the obvious consequence that there is less need for a regulator to spend public funds in that territory. Now, Dr. Varzaly pointed in her 2021 article and has returned today to the observation that there are relatively low net recovery amounts in respect of actions of this kind. I should pause there to note a really complex question. I never answered it successfully in 5 years of class actions. I've never had the opportunity to answer it in 13 years on the court. But really, it depends what you compare the recoveries with. And in particular, one needs to be a little cautious in comparing the recoveries with the notional value of a class action, the announced value of the claim when it commences. There are two problems there, one recognised by the courts and one studiously ignored by the courts. The one that is recognised by the courts is, of course, the difficulty of proof of losses in class actions, a matter which is becoming more apparent in recent class actions. The difficulty which has largely been ignored in Australian case law is the fact that we are looking at losses by reference to the nominal holdings of shareholdings. We have tended not to go behind to look at which losses are hedged and which losses, in fact, are shifted throughout the economy as a whole by more complex financial arrangements. Now, partly courts have not gone behind the nominal holdings because they can't, but if you don't go behind the nominal holdings, then it is you can't be sure that you do have an accurate appreciation of what the loss in fact is. In a third article, Dr. Varzaly deals with shareholder concentration, but I won't say much about that today. The great virtue, it seems to me, of Dr. Varzaly's work is her studiously committed empirical approach. That is, her approach is very much driven by data. Mine, by contrast, will be wholly impressionistic, so I will pass on my impressions for what little they are worth. In respect of directors' duties, it seems to me that Dr. Varzaly is absolutely right to note the significant level of activity in respect of public companies and the lesser level of public activity in respect of private companies, but equally that's not surprising and it's not something to be concerned with, where shareholders in private companies will normally have greater incentives and greater ability to protect their own interests. Continuous disclosure, the subject of Dr. Varzaly's second paper, and again something she has touched today, will of course be something that is very familiar to people in this room. In the detailed paper, I look at some of the recent case law, but here what I will do, given the relatively short time that's available, is simply make a couple of wider observations. The first is that the full court in Worley and the subsequent cases have now confirmed that a very broad view of awareness will be taken. So awareness will extend to matters to which officers ought to have been aware, and views that they ought reasonably to have formed based on available information, but not having regard to some of the later case law to information that was not known but might have been knowable by some process of further analysis. Secondly, of course, one thing that is apparent in this territory is an increasing trend for these actions to go to trial after a long period in which they simply didn't. And that in turn has demonstrated the real complexities in establishing losses in these cases, even when one approaches that question by reference to nominal shareholdings rather than by reference to economic interests. Third, an important observation, an important open issue, the decision in Zania Holdings against Commonwealth Bank of Australia, and the question of continuous disclosure in respect of regulatory matters. That case seems to me to be essentially driven almost wholly by factual findings with no novelty of legal analysis in it, and that's not a criticism of it, but it will be interesting to see what is found on appeal. Here again, it seems to me Dr. Varzaly's comments about substitution are obviously accurate, and they're also intuitive in the sense that this is an area where again one can see a limiting of ASIC's need for regulatory action by litigation because of the extensiveness of class action activity. Now, Dr. Varzaly commented less, but I will comment briefly about financial services regulation. And in financial services regulation, one must recognise the great unanswerable question, at least I find it an unanswerable question. Australia has invested, as have developed nations generally invested, significant resources in financial services regulation, both by way of the regulatory structure and by reference to enforcement. But nonetheless, both in the United Kingdom and in Australia, one sees recurrent cycles of investor losses. And that is a very difficult question to answer. Part of the answer may be the Hayne Royal Commission's answer, which points to the difficulties in moving from a sales culture that is well established to an advisory culture, and to the question to which the UK and Australia have slightly different approaches, whether that attempt is worthwhile, whether it is an attempt that ought to be undertaken in terms of protecting investors, however difficult it is to achieve, or the somewhat different approach of the UK, which is to seek to be more visible about the fact that some activities are in truth sales activities and not advisory activities. Here, of course, there are a series of attempts at reform, including, from my perspective, positively, the design and distribution obligations and the product intervention powers. And those seem to me to be philosophically desirable, notwithstanding the complexities that they have no doubt involved for industry so far as they shift a significant part of the onus of design of suitable products and of judgments as to suitability to product issuers. Obviously, in this area, we have the continued open issue of complexity, although happily, I think the Australian Law Reform Commission has largely avoided the temptation of mistaking complexity of litigation and causation of misconduct, because the two are very different things. I'm sorry, complexity of legislation and causation of misconduct, where the two are very different things. Plainly, the question of whether the Australian Law Reform Commission will prompt a significant reform of Chapter 7 or of the Act of the Corporations Act generally, which would be a vast exercise, which would likely outlast at least my professional career, is a question that is still an open one, although the reasons for such amendments are clear enough. Now, plainly, the Hayne Royal Commission in turn emphasised the desirability of litigation, and we have seen a significant escalation of penalties within the Australian regulatory regime. I do want to make one slightly cautionary observation, which is if one looks at the international experience and the academic commentary on the international experience, one is driven to the conclusion that larger penalties find it difficult to achieve regular objectives. That's the linguistic complexity of that sentence reflected the difficulty of putting the proposition I was trying to put politely. The difficulty that is fundamental in this territory, recognised in the United States, is the existence of scilla and charibitis. Scilla is the fact that we can't afford to impose penalties on larger financial institutions that will put them out of business. Charibitis is the fact that anything less than a financial penalty that will put a financial institution out of business ultimately becomes a cost of business. It is paid by shareholders, it is paid by consumers. Over time, it simply flows into the larger economy. So that, of course, has not prevented an escalation of penalties in the United States, the United Kingdom, or Australia. But the fundamental difficulty in that respect is the circularity of financial penalties. Here, of course, there is room for optimism. The banking executive accountability regime and now the financial accountability regime are things that avoid that question of circularity by focusing more on individual accountability. Far be it from me to really be controversial today and suggest that the government could always consider a further extension of the financial accountability regime working downwards into the financial services industry, a matter which would not, no doubt, not be welcomed by industry, but also a matter that plainly would be something that would need to be implemented if it were implemented at all over time. Now, finally, in the last 2 or 3 minutes, I thought I could make some comments about the Senate Economic Reference Committee's July 2024 report. In an academic, and I should emphasise, not in any judicial capacity, and of course, by way of self-designation, in an entirely balanced fashion. I do have several comments to make. The first is the passage of my professional career over some 35 odd years could be measured by the cycle of adverse reports about ASIC. I'm not sure whether they're every 3 years or they're every 4 years, but they come in a regular cyclic fashion. And oddly enough, they seem to come, notwithstanding that ASIC pursues substantial enforcement actions, and that those are the targets of those who are the targets of those actions regard those actions as substantial, threatening, and often oppressive, at the same time as ASIC is criticised for its lack of enforcement activity. Second, the report recognises, and it is plain, that there is an expectation gap in respect of ASIC. Unsurprisingly, it is blamed by consumers who suffer loss for not protecting them against misconduct. And sadly, however often it points out that it is impossible for it to create a financial system free of a fraud risk and free of a misconduct risk, however often it says that, it will not cease to be blamed for losses suffered. Third, there are other ways to assess ASIC's performance to that adopted by the committee. In particular, the Financial Regulator Assessment Authority in 2022 undertook a detailed review in a somewhat different approach of ASIC's performance, and both Dr Varzaly and Emeritus Professor Ramsey and his collaborators have undertaken statistical analyses, empirical analyses of ASIC performance. That is another way of expressing a degree of caution about the case study methodology in this area. The Senate Committee's report of several years ago focused on agricultural schemes. This report gives a significant weight to the Courtenay House matter, but case studies do have the risk that they tend to select from a universe of cases, and the selections are not always representative. Fifth, I couldn't resist this. It did seem to me a little unfair to criticise ASIC for delays in judgments in civil proceedings, a matter which Dr Varzaly noted, because it did seem that from my perspective, ASIC probably had to take the litigation process as it found it, and it no doubt would like a litigation process that moved much more quickly than litigation generally does. And that is in part because litigation as it exists, including in civil penalty proceedings, is astute to protect the rights of defendants. Sixth, and there are only two more matters to go. Sixth, so far as the committee, or at least some of its members, supported a separation of ASIC's functions between a company's regulator and a separate financial conduct authority, plainly that recognises the width of ASIC's jurisdiction and the challenges that that raises for ASIC. But these questions are not easy, and you might ask yourself the question, let us assume you have two regulators with the same resources, likely greater administrative costs and boundary issues between them. Is there any real reason to think that that separation will ultimately improve regulatory performance? Finally, I want to observe that there seemed to me to be force, another polite term, in several of the government senators' brief additional comments at the end of the ASIC report, which recognised the complexity of the issues, the competing considerations between the breadth of ASIC's enforcement role and the risk of it being spread too thin, and the risks of the common misunderstanding that ASIC is a complaints handling body, so that those who complain to it are so often left disappointed about the outcome. Now, all of these issues are impressionistic. A number of them are complex. For some of them, I have no idea of a potential solution. But happily, Dr Varzaly's work at least gives us a sound empirical basis to answer some of those questions.
Thank you both so much for many interesting comments. We're going to open it up for questions. In the room, anyone that would like to ask a question, we've got roving mics with wonderful Lisa there. And if you could just maybe stand or sit, but let us know, if you're from a particular institution, or just let us know who you are. So anyone want to kick off? And Tamara, you've got the online. Anyone online? We've got one. Well, why don't you come up and tell us the one online while the shy people in the room, yeah. Or you go from there.
Okay. It's a question from Reese Bolin. Thanks for the presentations. Good to have a thoughtful consideration of these issues. What is the optimal level of enforcement? I don't think the number of cases run per year is the best measure. I suggest it's probably more about keeping misconduct to an acceptable, in quotes, level. Difficult to define, but as an example, we have some analysis on levels of insider trading versus overseas.
Who wants to address that? I guess why don't you come up? And is Reese involved in your course at the moment? Or
Not this year.
Not this year. He was last year. No. So the optimal level.
Yeah, I think that's something when I started my studies, especially when I was first at Oxford, I was like, I want to know the optimal level, I want to measure deterrence. And like from going to all these brilliant institutions around the world, what everyone tells me is it's impossible to measure deterrence. There is no optimal level of number of actions because you're never going to know the universe of breaches. So that's why when we look at deterrence, it has to be a theoretical argument made to say, well, what are the types of things that give us an idea of the level of deterrence in any given jurisdiction. And that is why I, for example, looked at the number of cases a year. You don't know how many breaches there have been, but you can see how many actions and how many judgments there have been. And then you can look at, as I have done, using some of the international frameworks that have come out of scholars from Harvard and Oxford, you can look at, well, how many companies do we have in Australia? How many directors? What is the probability that a director of any given publicly listed company will face an action? And that gives you an idea of the likely deterrent effect. So in my analysis here, when you're looking at 0.08 or 0.04, that's a low percentage, right? You don't know the universe of actions, but the fact that it's less than a 1% chance that any director of a publicly listed company in Australia will be, a defendant in a particular judgment or action, it tells you that that's not a high figure. So I think we can't speak to or measure at the very least what is optimal, but we can look at what is the likely deterrent effect as a result of the number of actions we see in this system based on the number of publicly listed companies and the number of defendant directors. So that's kind of been my approach to that. So sorry not to have an answer to optimality, but I think you can look at likely deterrence, and then in that regard, I think you don't want to have over deterrence either. So we don't face that in most cases in Australia, or at least in what I'm looking at. But if you have a system where, say that percentage was 50%, you'd say that this is going to make, create an environment where people, qualified, wonderful individuals are going to say, hang on a minute, do I really want to serve as a director on a publicly listed company if it's going to mean that there's going to be, that high of a chance of there being an action initiated against me? So in looking at what is optimal, I think those are the things to keep in mind: under deterrence as well as over deterrence. And yeah, I think that's probably as much as I can say to that point. Yeah.
You want to say anything else? Yeah, but actually, why don't you both just stay close?
Okay.
I did want to make 2 or 3 comments, because that is such a good question, but it is also such a hard question. The first is that this 0.8% prospect that a director will face an action in a year is a really interesting observation. It sounds very low, but if you actually do some mathematics over 10 years, 10% of directors in Australia, and I don't know whether this is the class of public company directors or proprietary companies, or 8% would face such an action. And that's a relatively high percentage. If you talk about the body of public company directors, who one might think are normally trying to do their job well, then that's a relatively high level of action. The second observation I would make is that in some respects, this is a question we will never need to answer, because enforcement activity will always rise to the level of the regulator's enforcement budget. But the ultimate constraint, and it's a constraint that is recognised by the Senate committee in its report, the ultimate constraint is on the community's ability to fund enforcement activity, and even more so if you try to fund enforcement activity with a focus on the most expensive way of doing it, that is by contested litigation, rather than by, for example, enforceable undertakings, infringement notices, banning orders, and the other less costly alternatives.
I think that's a really interesting point, that it can be viewed as being quite high, because I think many directors in Australia, or many people who have said we would never become a director in Australia, do think that the risk is significant in Australia. And particularly after cases like Centro litigation, where I think a lot of people felt, gee, there but for the grace of God, go we all. I think there are quite high levels of concern in Australia. In terms of the optimal level, also I would note that historically in the US, there has really been zero, possibility of directors being liable for this sort of breach of duty of care type scenario. And that's as a result both of the hugely much broader business judgment rule in the US, and also the fact that it's not illegal in the US to have exculpation clauses for breach of duty of care, whereas it is in Australia. But one of the interesting things about the US is that is all changing at the moment with this new breed of cases that's coming out and reinterpreting what a very famous case, the Caremark case. And so we are now seeing, when you've got significant risks like Boeing, safety, that courts are saying that's not just a duty of care matter, that's a duty of loyalty matter. Now, is that Michael Lishman with his hand up? Okay, yes. Michael, you've got
on the sort of 1 in 120 chance of getting potted by the regulator, the other factor from a director's point of view is the consequences of that. So it might appear to be statistically low risk, but the consequences are awful. These things don't resolve themselves in 5 months. It's 5 years and reputation, and you don't get appointed to another board and so on and so forth. So anecdotally, without the benefit of any data, from just having advised people over the years, it is a deterrent. People are very afraid of these actions being taken.
And just ongoing stress for a long period of time. It's quite serious invasion in people's lives. So it's significant from that perspective. Any more online? No? Any more in the room? Yes. James Shipton. He needs a mic. Lisa, thank you, or someone. Yeah.
Hi, thanks. I'm James. I'm an advisor on the CLARS board, and I used to work at ASIC. A couple of questions for you, Jenifer. Thank you very much for the great work that you're doing, and I think this is great to have the level of precision and detail that is lacking in the discourse to date. Just on the Justice French made a very good point about the breadth and depth of ASIC's remit. In your work and your statistics, are you doing an apples-to-apples comparison with the FCA and others? Because, of course, they do have a narrower jurisdiction. The other point which I wanted to pick up was your theoretical bases of some of your conclusions. Is it possible that the publicity theory pervades every other theory? So it's not a matter of or, it's a matter of and.
Thank you very much for your comments. Yeah, so I think with the first point on the comparative data, I agree, like every regulator is different. I set out originally to do this as a comparative study, but then quickly realized that the methodology would be flawed if it was a straight up, I'm looking at what we do in Australia, then what happens in the UK and what happens in the US. So the comparative figures I take from other scholars' work in this space. So they have done the comparative assessments and found those probabilities. I've worked exclusively on Australia and then take the comparative figures where I can. But I understand that there's a different context of agency in every jurisdiction I look at. And I think that going back to some of my more positive comments that I made on ASIC is that I think some of the perception overseas is that, well, like ASIC is charged with so much and ASIC does do a good job. I think that's in other forums overseas, the view of people, because they say ASIC, they publicly enforce directors' duties. Wow, like, we don't do that in the US. It's private enforcement has to do that. Or in the UK, yeah, we say on paper that might be the case, but how many cases do we have? Almost nothing where we see any out-of-pocket liability ensuing. So I think that's a very good point to say that, I can only look at the action data and the regulatory data within Australia, and then I take the comparative figures, but certainly the context is slightly different in that regard. And then, sorry, can you repeat the second?
The publicity theory pervading the others.
Yeah, so I think that, yeah, absolutely. I think that, there are the three theories, and I think that the publicity theory seems to be consistent with the results that we see in general. I think the other two theories are there. Yeah, it can certainly be viewed as an end in all cases with the shareholder dispersion theory and the substitution theory. But I needed all three to cover aspects of the data set that weren't solely covered by the publicity theory, if that makes sense.
Yes, question.
Yeah, hi, my name is Ashish. I work for Deloitte, the risk consultant. I just have a general question. Recently, there's an article by the treasurer saying that ASIC is failing and that we need to dismantle it. We know that ASIC has known to, ignore breaches. So this the last theory, sorry, was that the publicity theory is I'm trying to understand. Is it trying to hide behind the publicity theory? The ASIC. I'm talking about ASIC.
So the way I've kind of termed the theory is that, I mean, I think this is true around the world. No regulator can pursue every suspected breach of duty. So on sort of looking at, okay, this is our budget, these are our resources, this is how many employees we have, they have to select which cases they will pursue. And that theory states that they will select those within, you know, with notable public figures in large publicly listed companies to try and get, I suppose, some behavioral correction outside of those companies, because that will be in the media and allow for, you know, reputational sanctions and other behavior correction that doesn't just come about as a result of that specific case, if that makes sense.
Well, I think one of the best examples of that a few years ago was when the son of a former Australian Prime Minister said, you've only, you know, brought proceedings against me because I'm the son of a former Prime Minister. And ASIC went, yeah, your point is, you know, like, obviously. Another question here?
Yes, Eugene Teo, Melbourne University. This picks up on the judge's point before about how if you aggregate the percentages, they do become more significant. Dr. Varzaly, I wonder if you have any information on whether individual directors were implicated across more than 1 year, whether for different companies or otherwise, and whether through public action or private action.
Yes, I would have that in my data set itself. But I didn't look at it so much on a director basis as more so on a company basis. And then I recorded how many actions occurred within the company and how many directors were sued, as opposed to looking at the names and then correlating that across time. But certainly I agree with all the comments made. You know, I think looking at the probability of having an action brought against you, it doesn't give you the depth of analysis or depth of understanding as, you know, saying what has been said in this room tonight. I totally agree with saying that if you are subject to such an action, I think, you know, looking beyond just the fact that, hey, maybe there's a pecuniary penalty for only $30,000. Beyond that, the reputational sanctions, the loss of confidence in what you do, the perhaps that you can't get a job in future, and the time that this takes from, you know, your activities and all of those things, you know, that goes far beyond the strict legal enforcement that we see. And I think that sometimes gets missed in these reports as well, and in the criticism we see, because a lot of it focuses, and, you know, I have this in my work, you know, some of the previous reports that I refer to, they say, oh, well, you know, we need to increase the penalty, you know, maximum amounts, we need to lift these ceilings and, you know, do all of this sort of stuff. But, you know, that's not borne out by my research. You know, in many of these cases is actually, you might say, a lot of these don't approach the statutory maximum amounts anyway. You know, something that I mentioned that might be more effective would be to say, okay, perhaps there should be a minimum penalty amount if that is what is desirable. Or we could look at, when we look at the penalty amounts in general, the data doesn't show that there's, you know, a problem with that. It's more about, you know, the breadth of all these results that we see from these actions that give us the depth of that analysis, and once again taking into account the private and public. So yeah, no, thank you, that's a very, very good point.
And I think it's interesting in the US context, the fact that the compensation, if a breach is found, is so astronomical that judges have explicitly said, we're not going to, you know, allow non-executive directors to face $275 million damages. You know, that would be insane, and which is, you know, part of the story of why there's so low levels of enforcement there. We're going to wrap up now, but before we do, I would really like to thank some people who behind the scenes have done amazing stuff. Tamara Wilkinson, my colleague from CLARS, and who also teaches corporations law with me, and from King & Wood Mallesons, Lisa Jones, who's just, thank you so much, Lisa. We're so grateful to you. And we're also particularly grateful to you, Diana Nicholson, who, when I phoned Diana and I said, how would you like to run a seminar with us? And she said, sure, I'm busy at the moment, but yeah, we'll do it. So thank you, Diana. It's been really a great experience. I wanted just to mention to you all, we've got another very good seminar coming up in September, which will be Joanna Bird, who was a senior enforcement officer at ASIC. She's going to be teaching a course for us at Monash on regulation and regulators. So anyone that wants to attend that, welcome. But she'll be giving a seminar, and James Shipton, thanks for asking a question, James, and thanks for being the commentator for that seminar. So keep an eye out for that in September. If you're not on the CLARS mailing list, please go onto our website and you can just sign on or send me a LinkedIn invitation. And I usually put stuff up in advance so that you know what's going on. But the main people to thank tonight are our speakers, Jenifer and Justice Black. So if you could join me in thanking them.